5, 4, 3, 2, 1, start.
For the offence under Section 302 of Indian Penal Code for causing murder of Ravinder was tried by the Court of Sessions through Sessions Case number 298 of 5 August 2000 emerging from FIR number 40 dated 2 May 2000 registered at Police Station Bhiwani, District Bhiwani, full stop. By giving reasons, trial court found the appellant guilty by judgment dated 10 September 2002 for committing of offence under Section 304 Part 1 of IPC instead of Section 302 of IPC, and according wide order dated 12 September 2002 was sentenced for a period of 10 years rigorous imprisonment along with fine of rupees 2000, and in default of payment of fine to further undergo rigorous imprisonment of 3 months. Full stop. Stanza. Complainant Vishal, resident of City Bhiwani, being complainant and eyewitness, got lodged his statement at 1 p.m. on 2 May 2000 at Government Hospital Bhiwani, full stop, stating therein that he is employed in BTM and yesterday he did not go to attend the duty and remained present at his house, full stop. There is a house of Ravinder situated in our mohalla who used to do service in the cloth shop belonging to Nehru Market, full stop. He is having 2 houses, full stop. He has given one house on rent to Sittu, who does the work of stitching at Vishal Tailor Mini Market, and he has been residing along with his family and he does not the work of stitching at home also, full stop. Ravinder has settled his residence in other house along with his children and mother, full stop. Children of Ravinder are not present at home as they have gone to parental house of their mother, and mother of Ravinder was present at home, full stop. Stanza. Yesterday in the evening at about 7, Vicky and Ravinder both were drinking liquor at the house of Ravinder, full stop. After drinking liquor about 11 p.m., both of them came into the chowk in front of house of Vicky, full stop. Both exchanged abuses between each other and they were making noise, full stop. On hearing their noise, I and Kamlesh, who were already sitting in the Shakti temple, went towards them, full stop. Both of us reached near chowk, full stop. Ravinder was saying to Kamlesh that you have not paid the rent of the house, give the same in morning, full stop. At that time, light of the house of Kamlesh was on and there was light in the chowk also, full stop. Within our sight, Kamlesh got hold a scissor within bracket canchi from his house and gave its blow to Ravinder, which hit directly on the left side of his neck, which started bleeding profusely, and Ravinder fell down on the ground, full stop. On his serious condition, Kamlesh fled away from the spot along with scissor, full stop. He refused to suggest that he is an introduced witness in order to convert the blind murder case into an eyewitness account case, full stop. Similarly, another eyewitness, that is Suresh, appeared as PW7 and corroborated the statement made by the complainant, full stop. In total, prosecution examined as many as 12 witnesses, full stop. Mr. Jagdeep Singh, learned amicus curiae, made his first attempt to seek clean acquittal by making submissions that there are material discrepancies in the case of prosecution, full stop, such as injury suffered by the patient is shown as 7.2 inches in depth, whereas recovered weapon of offense is the scissor within bracket canchi, whose blade's length is 5.5 inches, full stop. Learned amicus curiae further submits that recovery witnesses have been given up by the prosecution being unnecessary, full stop. The arguments of non-production of the recovery witnesses would not be material because deposition of PW12 would be sufficient in that regard. Full stop stanza. Appellant was arrested by him on 3 May 2000 and on his disclosure statement a seizure was got recovered. Full stop. Thus, there is nothing available on record from the cross-examination done by the defense that in any manner recovery of the weapon of offense at the instance of the disclosure statement of the appellant can be said to be doubtful. Full stop. As far as argument of 8 inches depth of the injury is concerned, there is nothing asked from the doctor during cross-examination by defense counsel as to whether the said depth could be possible or not if the injury is inflicted with the weapon seen and opined by him. Full stop. Had there been any question in specific, there was a possibility of giving of an explanation on record by the concerned doctor, that is Dr. Rahul Mittal. Full stop. This omission on the part of the defense in asking a pertinent question cannot be extend any kind of benefit to his credit. Full stop. Thus, this argument of the appellant fails. Full stop stanza. It is further argued by learned amicus curiae that in the absence of any strong motive, it is unlikely that appellant would cause murder of anyone. Full stop. Moreover, alleged motive of having tiff on account of non-payment of rent does not appear to be a sufficient reason of causing murder. Full stop. So it is unlikely that appellant would have caused murder of Ravinder with alleged fatal blow. Full stop. This argument also is not sufficient for convincing the conscience of this court because as per case of the prosecution, both, that is appellant and Ravinder, were sitting together since 7 p.m. and were drinking liquor. Full stop. The tiff oblique arguments in loud voice started around 11 to 11:30 p.m. Full stop. In all possibility by that time enough alcohol had been consumed. Full stop stanza. Thus, in the rush of blood, exchange of hot words started, resulting into suffering of injuries by victim at the hands of the appellant. Full stop. Thus, this argument is not applicable. Full stop. Learned amicus curiae also pointed out some contradictions in the statements of both the eyewitnesses. Full stop. Undoubtedly, there are some contradictions, but these cannot be stated to be major. Full stop. This court, on examining the exhibited documents, finds that alleged incident took place around 11 to 11:30 p.m. at 1 April 2000. Full stop. Statement is recorded by SHO Dheeraj Sharma on 2 May 2000 at Government Hospital Bhiwani at 2 a.m. that is within 2 hours of the incident. Full stop. Thereafter, Ruka is sent to the police station and same is received at police station 3 a.m. and thereafter special report is received by the concerned magistrate at 6:10 a.m. on 2 April 2000. Full stop stanza. It shows that FIR is registered without any concoction and manipulation or padding. Full stop. It is not possible for the prosecution agency to register the first version from the mouth of the eyewitness of the incident, mentioning therein the names of both the eyewitnesses. Full stop. The receiving of special report has been proved by sole witness PW1 who delivered FIR to the Ilaka magistrate and proves the receiving by the magistrate. Full stop. From the cross-examination, nothing material has been taken out for the benefit of the appellant. Full stop. Thus, registration of prompt FIR is another factor reflecting the truthfulness of the case of the prosecution. Full stop. Considering all the aspects and incident arising out of a tiff over a petty issue without there being any prior motive, already learned trial court thus converted the offence to that of section 304 part 1 of IPC from section 302 of IPC. Full stop stanza. At last, learned amicus curiae points out that offence can be converted to section 304 from section 304. Therefore, to that extent, judgment of conviction requires some modification, full stop. For strengthening the said argument, learned amicus curiae has cited some judgments of the Honorable Supreme Court, full stop. From the said judgment, learned amicus curiae submits that deceased victim had suffered total 11 injuries and the appellant therein was convicted for section 304 of IPC apart the other offences, full stop.